Thank you for joining us this afternoon. My name's Hugh Roth. I'm a director here in the disputes team, and I deal with commercial litigation, and included within that is our claims related to breaches of restrictive covenant and misuse of confidential information. My colleague Juliet, she's a legal director in the employment team, and she comes from matters from a more non-contentious aspect, certainly today, although her practice does also include contentious disputes. The intention of today is really to give you a whistle-stop guide on restrictive covenants and what can be done to protect your business's position, what the law will protect and what the law will not allow you to protect, and also to discuss what steps can be taken if you come to information that there has been a breach of any restrictive covenants, or you suspect that an employee or a former employee is misusing what you consider to be confidential information. I will initially deal with some background as to the court's general position. Juliet and discuss the standard clauses which are generally included within contracts. Juliet will then take over and discuss drafting tips, and then I will come back in at the end of the webinar to discuss what can be done if we suspect there's been some wrongdoing by a current or former employee. So just to start off with, I think it's important to note that the courts, the starting point is that the courts are very reluctant to enforce restrictive covenant as a matter of public policy. The courts don't like to interfere in a party's right to work and compete, and that is always an important starting point to bear in mind. It is important to bear in mind that the burden is always on the employer to prove that the covenant goes only so far as is reasonably necessary to protect the employer's legitimate business interest. That may be securing confidential information, client connections, whatever it may be, but it's always important to bear in mind that ultimately, if there is a dispute, it will be for an employer to prove that the covenant is reasonable and it goes only so far as necessary. One of the reasons behind this is obviously the court looks at the bargaining powers between the parties, and it considers that an employer is in a stronger bargaining position to an employee. The position is slightly different to if these covenants are included within a contractual document, such as a share purchase agreement, where maybe a former shareholder has sold his or her shareholding to a business, and as part of the agreement is continuing to be employed by the successor business or the purchaser. The courts allow a greater deal of flexibility when we're looking at share purchase agreements and restrictions contained within those. We're going to focus mainly on employment contracts in today's webinar, but I think that's important to bear in mind, and the difference in likelihood of clauses being deemed to be reasonable. Looking at the various types of restrictive covenants included within contracts, I would say that you probably have 3 or 4 fairly standard covenants, which most of you will come across in your businesses. The first, and probably it's fair to say the most controversial, is the broad brush non-compete covenant, and that essentially says what it does on the tin. It's an attempt to stop a former employee from competing full stop in a competing business. Because of the nature of the restriction, it's fair to say it's probably the one the court will be most reluctant to enforce. There'll be a difficult hurdle often to prove that broad brush non-compete clauses are within a legitimate business interest and go as reasonably necessary to protect those. The other clauses that are often found in these contracts are non-solicitation clauses. Essentially, that is a restriction on a former employee approaching positively taking an act to try and work with clients or customers whom he or she previously worked with at a former employer. So it's really looking at a positive act by a former employee to work with former clients and customers of the former employer. And that really is the difference between a non-solicitation clause and a non-dealing, because a non-dealing clause goes further than a non-solicitation clause and prevents the former employee providing any services to former clients, customers of the employer. You could argue, therefore, that a non-dealing clause is more powerful, and I would agree with that. It goes further than a non-solicitation clause, but by its nature, it's therefore often more difficult to persuade a court that it is reasonable. And Juliet will talk in general terms about the factors a court will look at when considering whether non-solicitation clauses and non-dealing clauses are deemed to be reasonable. Things like geographic locations and length of time, seniority of individuals, and so forth. But I'll let Juliet discuss that later. Non-solicitation clauses and non-dealing clauses often go hand in hand. They will be within the same contract of employment. They complement each other, but the non-dealing clause goes further because it doesn't require a positive act from the former employee to entice a former customer. A former customer can approach a former employee, and if there's a non-dealing provision within the contract of employment, in theory, the employee cannot provide those services during the period of restriction. The non-poaching covenant is the final covenant I want to briefly discuss, and that essentially is aimed at preventing a former employee from encouraging other employees from joining and leaving the firm. It's to protect things like team moves and so forth, and it's often quite an effective bolt-on to the usual covenants that we see within the contract of employment. Juliet, I don't know if you want to discuss take this further forward.
Thank you very much, Hugh. Can I just as well remind people that we do have a chat function and there is a Q&A box. We have had one question sent in advance of the webinar, which we'll deal with at the end. But if anybody has anything they want to ask or contribute, please feel free to pop it in the chat box and we'll try and pick that up later. As he says, I'm going to touch more on the drafting of these covenants and the types of issues that employers need to bear in mind. The difficulty with this topic is that, in essence, it's huge. And it would be impossible for the purposes of a session like today to go through all of the benefits, perks and pitfalls of introducing restrictive covenants into your employees' contracts. So what I'm going to try to do is just touch on some of the headline areas, but I think the underarching and overarching advice is that you must always look at each individual employee or employee role and business in isolation and consider, in respect of each, what is an appropriate restrictive covenant to impose, if at all. So, as he says, starting point is these types of covenants are prima facie unlawful as being restrained trade. But what we have seen build up over the years is that there is capacity and facility for employers to introduce such covenants into contracts of employment if they can demonstrate that they have a legitimate interest in doing so. A legitimate interest is going to be more than the employer just saying, well, I've worked really hard and I want to make sure that none of my employees come in and steal stuff from me. when I've worked all these years to build that up. The employer is going to have to demonstrate that there is actually an interest that they need to protect. And the types of interest that the courts have recognised are legitimate will be your trade connections. So if as a business you have particular relationships with specific customers, specific clients or suppliers, or more generally, the nature of your business is such that you've built up an element of goodwill in the market over a period of time, although we'll come on to what issues might need to be borne in mind in such regard in due course. But in essence, the starting point is that those types of connections will be properly protectable. The other legitimate interest is are the trade secrets and other confidential information. So if there are particular recipes, for example, that a particular business is using in order to manufacture its product, then that type of confidential information, or if there's a particular pricing structure or client list, it's those types of matters that we're seeking to protect, and not obviously allowing employees to take with them as and when they exit the business. And then the third one, perhaps not so widely considered, is stability of the workforce. And this comes back to the non-poaching that Kira's just talked about. And it's making sure that the employer can legitimately protect itself from the fallout if all of a sudden one employee leaves and within weeks of doing so takes the rest of the workforce with him or her. So moving on, once we've established that we have a legitimate interest that we need to protect, what the employer is then going to need to do is go on and demonstrate, if a clause is to be enforceable, that what it has done is no more than necessary to limit to protect the legitimate interest. And picking up again on points he's already made, the relevance here is going to be, and the starting point is always going to be, is to consider the limit of the restrictive activities, the period for which you are restricting that individual, and if appropriate, the geographical extent of the restriction. It is a balancing exercise between the interest of the employer's business and an individual's right to freedom of movement and to earn a living. But what you need to do, obviously, is carry out that balancing exercise at the point of drafting these covenants and making sure that you're doing enough to protect yourself, but it doesn't go too far and effectively becomes void and unenforceable. Just a point worth noting there at the bottom, reasonableness is judged at the time the covenant was entered into. That might sound like it's stated in the obvious, but it's actually a very important point. And it's important to note that you need to draft your restrictive covenants in relation to the particular employee at the particular point in time, and not with a view to where they may go in your business in the months or years to come. So, looking from the employer and the business's perspective of what kind of factors you should consider when you're drafting your restrictive covenants, a description of the business is going to be key. It might sound like it's stating the obvious, but if you don't describe your business, if you don't explain what the nature of the so-called restricted business is sufficiently clearly, then you are probably going to find either that you have a covenant that's unenforceable, or you have a covenant that's not worth the paper it's written on, because it doesn't actually prevent your former employee from competing or dealing the way you want to. So making sure that you have an accurate description of the business is always the starting point. It's also important to note that this isn't a one-size-fits-all, and I'll come on to that in top tips in a few slides' time, but it is important to consider what parts of the business the employee will be involved in, and where your business is based and where you do business. It's not going to be enough to restrict a particular employee's ability to deal in any way with any part of your business is actually the majority of that business they've never previously been involved with during their time working for you. So again, it's important when describing the business to also make sure that the business you're seeking to protect, or the part of the business you're seeking to protect, is relevant to the individual involved. And then just the point at the bottom there is, again, just think about these questions and how they're going to, and how your business is going to develop in the next year, in the longer term. And, you know, again, when you're looking at what and where you're seeking to protect, that you've got some flexibility in that with the changing needs of the business over time. Apologies, our slides taking a little time to catch up. I do apologise. Factors to consider when drafting restrictive covenants from the individual's perspective is almost like a flip on its head of that. So look at what the job title and the job description is of the individual that you're seeking to restrict. Again, it's absolutely pointless to seek to restrict them from doing things that isn't actually part of their specialism or part of their role. Drafting too widely in this regard is almost certainly going to result in the covenant being deemed unenforceable in due course. But also consider whether there are any other businesses part of your group to which this employee provides services. Again, I think all too often we focus on the business that the person is actually working within and not recognising that that business probably forms part of a wider family of businesses. So do give some thought to whether in restricting the employee, you need to restrict them from all group companies and not just the one that they're providing services to on a day-to-day basis. It is important as well, I think, when you're recruiting employees into your business to think about what their career history has been. What have they done in their career prior to joining you? What did they do with previous employers? Where did they work? What services did they provide? And what was the nature of the role in each position? Because if you look at what they've done before, that's probably going to give you an idea of what they might do after their service with you is terminated. And it may well be that having that knowledge or having that input and insight is going to enable you to draft restrictive covenants that will properly protect you in respect of that employee when they leave the business. Look at their skills and look at other businesses which they could work for and other geographical areas in which they could work post termination of their service with you. Again, one eye on the past and one eye on the future is going to hopefully result in you drafting fully enforceable and protected restrictive covenants. And then when you're considering your legitimate interests that you are seeking to protect, there's a series of questions here that it's key for you to be asking yourself. So what trade secrets or confidential information are you seeking to protect? And realistically, does the employee you're seeking to restrict have access to that information? Again, make the clause relevant, make it relate to the person that you're seeking to restrict and not just a wider blanket restriction. What damage could be caused to the employer if they were to make use of the trade secrets and confidential information? And importantly, and this is something I always ask clients when we look to draft restrictive covenants, is how long is that confidential information be likely to remain confidential if it's going to come out into the public domain in due course in any event, or if at some point it will cease to be relevant or important to the employer's business, then bear that in mind, because again, the more you can do to restrict the covenants to what is actually reasonable and necessary, the more likely you are to have a covenant that's enforceable. Similarly, what trade connections is the employer wishing to protect? And how many of those trade connections has the employee actually been introduced to? How often have they done business with them? all going to be key considerations as to what degree you'll be able to protect that person or restrict that person after employment. Do these connections already do business with competitors? If so, then it is going to be much more difficult to restrict what this employee does post-termination if that client is actually already doing business elsewhere. And what damage could be caused to you if the employee made use of those trade connections. And then finally, in relation to the non-poaching, look at what key employees this employee will have contacts with, which fellow employees they are likely to be supervising, and consider what the damage could be to your relationship if the employee were to make use of those relationships. Again, there's little point in a blanket restriction of all employees. Much better to target the non-poaching to employees that they've worked in a team with, or who they've reported to, or who have reported into them. Next slide would be that. So,
sorry, takes time.
So just a quick run through of some of the factors to consider when drafting reasonable restrictive governance. Most of these we've already touched on, but as he says, look at the length of time that you're going to seek to restrict somebody for. It might be tempting to go for as long as possible, but there's no point in having a restriction that's too long if the net effect of that is going to be that it's unenforceable. It's far better to have a restriction of, say, 6 months than, say, 2 years and think, great, I've signed them up for 2 years, but then actually I can't enforce what I've signed them up to. So a reasonable length of time that protects the information, the contacts, the business that you're seeking to protect. Look at the seniority of the individual. It's not going to be appropriate to sign all of your employees up to restrictive covenants, and certainly not to the same restrictive covenants. So make sure again that the covenant matches the nature of the individual you're seeking to restrict. Consider the geographic location of where your business does business, and whether you need to be looking outside of your locality. Obviously, the wider the geographical location, the less likely it is to be enforceable. So if you're going to impose on, make sure that there is justification for doing so.
Next one. No, it's fine. We've had some questions. That's what I was going to add.
Okay.
Yeah.
And then just a couple of top tips. First of all, bear in mind that it's not only employees that can be restrained. I think we often think about this as being something that's part of the employment contract, but consider whether you want to restrain contract workers, casual workers, self-employed, consultants. In theory, it's possible to draft enforceable restrictive covenants in respect of all of those. Be wary and mindful of the requirements for proper formality and execution. Absolutely no point having a restrictive covenant if it's not properly recorded somewhere. So ideally these need to be in the contract of employment, or they need to be annexed to the contract of employment, and even more ideally that the employee has actually signed that document to confirm that they agree with them and agree to be bound by them. The one size fits all, very important. Don't just have standards set and apply them to everybody. Updating restrictive covenants, that's incredibly important, and the number of people we see recruit at junior level without restrictive covenants, that person then gets promoted through the business, but either restrictive covenants aren't introduced on promotion or they're not updated on promotion, and you have a set of restrictive covenants that aren't fit for purpose. Recognise the importance of protecting associated in group companies. Be aware that if you dismiss your employee in breach of contracts, then it is unlikely that you're going to be able to rely on the restrictive covenants. And then just a final point on that slide, be aware of the perils of social media, and in particular, the knotty issue of LinkedIn. If you're in any doubt as to whether employees are misusing confidential information or contacts on social media, please take advice. We'll start talk through, and I'll hand back to you to talk about remedies.
I think one point before I move on to discuss remedies, we've had one question about updating restricted covenants for long-standing employees, and that's a point that you raised there. I think it's vitally important that you keep in mind at what level you recruited certain individuals, and always regularly review whether they need to be updated. It's a fairly simple process to update restricted covenants. Of course, if the employee is willing to pay all, but it is always important to regularly review those, because it's something that's easily missed. It's not something that you would naturally look out for, but it's something that can give your businesses additional protection.
Sorry, you just one point on that. I think that's really important, because the nature of your business changes, but the nature of your employees change. The only point I would make is that if you are looking to update your restrictive covenant with a particular employee, the employee is almost certainly going to want to see some consideration for signing up to an updated or a new restrictive covenant. And so it may be that there needs to be either a one-off financial payment or an increase in salary as a quid pro quo for signing up to that. So be aware that absent consideration, the update may not be enforceable.
Yeah, and to add further on, perhaps an opportune time for doing that is when an employee is being promoted naturally. You'd imagine that as part of a promotion, they would be maybe asked to sign a new contract, but certainly getting an increased salary and so forth, and that would be the opportune time of doing it, rather than perhaps noticing that there isn't a restrictive covenant in place and then trying to persuade them after the horse is bolted, for want of a better phrase. And so I'm going to sort of now take on a whistle-stop tour as to what you can do if you suspect there has been a breach of the restrictive covenants and the post-termination restriction. It's very much a whistle-stop tour. I should say at the very outset, the first thing that is done generally is to write to the employee. May state the obvious, but nobody ever rushes immediately off to litigation. There's an obligation on parties to set out a letter for action, setting out the alleged wrongdoing, the information that you have pertaining to that wrongdoing, and inviting them to desist. And that's often done in the form of getting them to agree what's known as undertakings. You can get them to agree contractual undertakings to stop and to essentially cease and desist from what they're doing, whether that may be approaching customers or whether you suspect them of misusing confidential information, because often claims of breach of the post-termination restriction and misuse of confidential information go hand in hand. And so the first step will always be to set out in writing to the employee the nature of the alleged breach, inviting them to desist, and setting out what you say has been the loss to you as a result of the alleged breach. More often than not, that will actually produce a resolution that both parties are comfortable with. The threat of litigation is quite intimidating for employees, and there obviously is a cost involved from the employer's perspective. And therefore, more often than not, I tend to find that if a letter of credit is sent with undertakings sought, that a middle ground compromise can be achieved, and that the need to pursue litigation is avoided. That is not always the case, however, and in the more serious cases where, for example, you may suspect a team of moving as part of some sort of conspiracy, then that's not always going to be possible. And then you look at what court remedies the court could order, and the most immediate of these is an injunction. It's essentially an injunction, an interim injunction in the first instance, preventing the continuation of the act complained of, whether that may be soliciting clients or misusing confidential information. It's one of the more hard-hitting remedies, And so the court will only ever grant an injunction if it considers the balance of convenience is in favour of granting it. When it considers whether or not the balance of convenience is in favour of granting an injunction, it will look at whether or not, for example, damages itself are an adequate remedy. If the court thinks damages is an adequate remedy, then it will be unlikely to award an injunction. If it thinks the damages aren't in and of itself going to be an adequate remedy, then the court may well consider the balance of convenience in favour of granting an injunction. The court will also look at whether or not more harm will be done by actually granting or refusing the injunction, and look at maintaining the status quo through to a trial. And when looking at whether or not to grant an injunction, a court will often look at how swiftly a party has moved. If you are seriously contemplating pursuing an injunction against a former employee or a new employer, for want of a better phrase, we suspect induced a breach of contract, it is no good sitting on that. The court will expect a party to move expeditiously, otherwise it will think that the damages are an adequate remedy, and it will consider that the balance of convenience tips in favour of granting an injunction. The springboard injunction is a bolt-on almost to the ordinary interim injunction. It's where you suspect that a business has had a head, or a former employee has had a head start as a result of the unlawful conduct, and it's particularly useful in team move claims where you suspect that there's been a conspiracy to move teams from one firm or one business to another, and a court may, if it considers there has been unlawful conduct, grant an injunction for the duration of the head start a court considers has been obtained as a result of the unlawful conduct. I mentioned that often misuse of confidential information goes hand in hand with alleged breach of the restrictive covenant. So in addition to seeking injunction and damages, an order that is often sought is an order requiring delivery of confidential information and a witness statement from the employee that no further confidential information is within their possession. It's particularly pertinent if you consider that a former employee, say, has taken precedent documents, client lists, or sensitive financial information, things like that. If you suspect and have strong evidence that that's taken place, then orders requiring delivery up of those are fairly common and an effective remedy. The next remedy is damages. Often these sort of disputes aren't always about actually recovering damages. It's more about preventing the wrongdoing. But if you can demonstrate financial loss, which sometimes is difficult in a pure breach of restrictive covenant case, then you will obviously seek to recover those in any court proceedings. The final point I'd make is considering whether any third parties are liable. I briefly mentioned it in the context of a team move, but that may not necessarily be the case. If you suspect a competitor has been procuring the former employee or a current employee actually to misuse confidential information or to breach their post-termination restrictions, then you may have a cause of action against that third-party business, and it's often a pretty useful threat. Where if you write to the third party, if you have evidence that they've procured the breaches of contract, or that you have some sort of evidence that there's some sort of conspiracy between them and multiple parties to move teams, you may have a cause of action directly against that third party business. So my slide is temporarily frozen. Looking at confidential information, apologies, the the slide hasn't followed. The slide hasn't followed the on the screen, so I'll crack on as I'm conscious of time. It's one of the factors that I often get asked is about protecting confidential information, and during the course of the employment, that's fairly simple and straightforward answer. Invariably, they will be included within contracts of employment. Obligations not to misuse confidential information, and that is also implied during the course of, or certain duties are implied during the course of an employment. Where it becomes a little bit more complicated is what can be done in relation to protecting confidential information post termination. Now, some of the ways in which you can protect confidential information actually by including the restrictive covenants we've discussed already, because some of the information that we may be considered may be protected by incorporating the restrictive covenants. It is possible, however, to include express clauses within contracts of employment to ensure that trade secrets, for example, are protected post termination. Often we tend to find that cases of misuse of confidential information have actually occurred whilst the employee is still technically employed, but after handing in notice. And if that's the case, then the employee and the employer is protected by the express obligations within the contract of employment. In terms of what constitutes trade secrets, that can be special ingredients, special ways of manufacturing, things like that. What can't be protected post termination is information which has been acquired, which the employee has acquired, its skill and knowledge which is developed during the course of the employment. You may think that you've added value to the employee, but you can't provide express conclusions from them using the added value that you've added to the employee in terms of skill and knowledge to a new employer. That's unfortunately something that the court's fairly clear. You can't incorporate within restrictions within your contracts of employment. It may also state the obvious, but you can't incorporate any clauses which seek to preclude publicly accessible information. Now, if you publicize, for example, things on your website, things that you might consider to be potentially confidential, then if they're publicly available, then that's not going to be protected by any provisions within the agreement. Essentially, very briefly looking at the remedies that that are available to a party if there's been a suspicion of misuse of confidential information, then frankly, they're very, very similar to breaches of restrictive covenants. In looking at undertakings, you will write to an employee seeking an undertaking that they will continue to misuse any confidential information and will deliver any information within their possession, and that's the precursor to pursuing anything further in the courts. If that's unsuccessful, you will then look at the injunctions and potentially springboard injunctions and the damages or account of profits that I mentioned when looking at remedies for breaching restrictive covenants. The other thing that I'd always encourage parties to look at is whether or not there are IP or database right claims, and that may broaden the causes of action available to an employer against a former employee. If you suspect a former employee has downloaded databases and information about clients and so forth, then there are database rights, and there are claims that can be pursued for breach of the database rights, which are probably it's fair to say easier to pursue than standalone breach of confidentiality claims. There are also other copyright claims and other sort of causes of action that can be pursued if you suspect, for example, that an employee in joining a new business or in creating their own business have essentially lifted precedent documents and copied them word for word, or extremely similar. Then you may have IP claims rather than perhaps breach of confidentiality claims. So I always suggest that's something to bear in mind. And that really, really comes full circle to practical considerations when considering whether to take any legal action. It's always important to have the overall objective in mind, I find. You have to weigh up the cost benefit of taking any action. By that, I mean, if you suspect a relatively junior employee has perhaps breached a non-dealing covenant by acting for one former client on one occasion, and you don't think it's a significant and serious breach, then stating the obvious, you have to weigh up the cost benefit of whether or not you want to take further action. Some businesses will take a zero tolerance approach. They will take the approach that we can't be seen to be sacked at all. We will take up any and all potential breaches of post-termination restrictions very seriously, and we will write to any former employee. But it's always worth bearing in mind this level of seniority and the extent of the wrongdoing. It's important to remember that litigation is expensive and time-consuming. I don't want to talk myself out of work, I should say, but it's an important factor that everybody should be aware of at the outset. These sorts of disputes are extremely expensive because they move very quickly. If you have to apply for an injunction, a lot of work is necessary over a short period of time. And if an injunction is granted, there's a very condensed timetable. Matters are subject to speedy trials. That's because primarily the length of the restrictions. So a court likes to try and deal with matters as expeditiously as possible, so that if, for example, a court holds that there were no grounds to hold an employee to post-termination restrictions, the court tried to deal with it such that by the time it gets to trial, that restriction hasn't already expired. So it's a need to move very swiftly, and there's a lot of upfront costs involved. Even if successful, nobody ever recovers all of their costs, and that's something to bear in mind. And also something to bear in mind in some tips. Evidence gathering is important. If you suspect somebody of wrongdoing, it's important to retain electronic evidence, logs and records, things like that. That will always come useful if you choose to escalate and take the matter further. So that really brings me to an end of my presentation as to steps that you can take. I know we've had a couple of questions, and we had one before, which was essentially, what are the chances of succeeding with a case in demonstrating the enforceability of a covenant? And that's almost a piece of string, and it's an impossible answer because it depends, as you've seen. There are a number of factors that a court would consider when considering whether a covenant is reasonable. One size doesn't fit all, and we've seen some of the factors a court will look at, such as the seniority of an employee, the geographic restrictions of any restriction, the length of any restriction, whether the employer itself has been in breach, in repudiatory breach, which would undermine any restrictions in any event. There are a whole myriad of factors that a court would consider when considering whether a covenant is enforceable. So it's almost impossible to say these claims are easy to run or the claim is likely to succeed. because they're so fact sensitive. They turn on their individual facts. That's what makes them quite interesting often. We've had all sorts of different disputes, and Juliet and I could speak for another couple of hours, I'm sure, about the different types of issues we've come across and the nature of the disputes. We've had people covertly pretending to be other people, haven't we, Juliet, and things like that to try and subvert these covenants in the past. And there are steps that can be taken, but it's impossible to say without looking at the individual covenant that's being challenged, whether or not court is likely to consider that reasonable or not. We've had one more question, Julia. This is from Parole. Often the practice is just issue a letter setting out the new job description and salary, but the key terms of employment don't change. So when an employee is promoted, how do you deal with updating the restrictive covenant to reflect the change?
I think in short, you would be looking to issue either a new contract of employment at that stage or a side letter to the main contract, so a contract variation. I've seen it done both ways. So when somebody is promoted, it's like, here's the contract of employment that covers your promotion, and employers use that as an opportunity to introduce either restrictive covenants or amended ones, alongside maybe making other amendments to the contract of employment that come with the promoted role. Or alternatively, the core contract of employment can remain, but you can have an addendum or a side letter to the contract of employment that's signed on promotion and that deals specifically with any changes to the terms and conditions that come with the promotion. So I think really you're looking at either or, but effectively what you want is something in writing that records the changes to the terms and conditions, and that preferably is then signed by the employee to confirm acceptance, or at the very least that you're getting an email from them or something to say, thank you very much, I accept my promotion. You want something on record that demonstrates that the employees accepted that on the consideration point. That doesn't normally cause any difficulties in that type of scenario, because if somebody's being promoted, you could say that the promoted role is the consideration, or invariably there will be a change to salary, or there will be change to other terms and conditions. Maybe your sick pay entitlement increases as you're promoted. So really that's what you're looking for, is something that's recorded the consideration and recorded the employee's acceptance.
Okay, we've dealt with the questions which have come in. That's not to say that if you have any other questions that come to mind after the webinar is finished, feel free to contact either Juliet or myself. You can reach out to us on LinkedIn or via our website. Our details are on our website, and we'd be more than happy to deal with any questions and queries which you may have, which you don't think we've dealt with during the course of the webinar. I hope that you found the run through this topic interesting and fruitful. I'm just going to say on that point, I think if anybody is in any doubt as to whether they've drafted their covenants appropriately or they need to be reviewed, don't hesitate to reach out. We can certainly work with you in relation to your specific business or individuals within the business to check that where possible you're properly protected. I think the other point I just wanted to touch on very briefly, and it's a whole issue in and of itself, but just something that's brought to mind as Hugh was speaking about confidential information, is also just recognising that if you do discover that your employees have been breaching your confidential information, taking it elsewhere, sharing it, then depending on the nature of what they've taken, you might also find that they've committed a data breach, and that raises whole other issues. Again, I say if in doubt, take some advice, but if client lists are being shared, for example, and they contain the personal data of the clients, then although it's the employee that's done it, technically you're still responsible for the breach. So that raises a myriad of other issues, which we're more than happy to talk about
when we have more time, I'm sure. That was it.
No, as I said, if anybody has any further queries after the end of the webinar, they can feel free to reach out to Julia, to myself. And that's all. Thank you very much.
Thank you very much.